Hey guys, it's been a minute since I've been on, but I wanted to do a video on slander, a brief video, because I've seen so many people say that they could get somebody for slander or defamation or libel, and I wanted people to have a kind of a general understanding of what that is and exactly what you're saying. And if you've been accused of that, I wanted you to kind of see what your options were. But tell you a little bit of why I've had a little absence from YouTube. On Christmas Eve night, I caught the flu, and then directly after that, I had pneumonia, and I still have pneumonia in my left lung, and I've been battling a migraine for a couple of days now. So, I had a death of a family member on the 27th, and I guess just the stress of that just brought on the migraine. But anywho, wanted to do this video on slander. So, I thought we would first start with the definition, the legal definition of slander. And I pulled it up from the law dictionary, and I've got it here. Apologize for that. Okay. And I'll read it. Slander. Oral defamation in which someone tells one or more persons an untruth about another, which untruth will harm the reputation of the person defamed. Slander is a civil wrong, tort, and can be the basis for a lawsuit. Damages, payoff for worth, for slander may be limited to actual, special damages unless there is malicious intent, since such damages are usually difficult to specify and harder to prove. Some statements, such as an untrue accusation of having committed a crime, having a loathsome disease, or being unable to perform one's occupation, are treated as slander per se, since the harm and malice are obvious and therefore usually result in general and even punitive, which is monetary, damage recovery by the person harmed. Words spoken over the air, on television or radio, are treated as libel, written defamation, and not slander, on the theory that broadcasting reaches a large audience as much as, if not more, than printed publications. And it says, see also defamation, fair comment. I found a video that's, not too lengthy, that kind of sums up everything. So I thought I would play that. And I'm going to try to get right to that. Apologize. Let's see if it'll pull up for me. Let's see. Just watched it. Here we go.
I hope this finds you well. Today we're going to look at the common law rule for defamation and how slander and libel play into the defamation rule. The landmark Supreme Court case is New York Times versus Sullivan. We won't go too in depth with New York versus Sullivan in this video, but I do intend to create a case brief for New York Times versus Sullivan in the near future. So let's look at the elements of defamation. There's either 4 or 6 elements when trying to prove defamation. Your regular run-of-the-mill defamation is only 4 elements, and when the defamation concerns a matter of public concern, well, then you get the 2 other layers of defamation. So here are the elements. There first must be defamatory language. It must be of and concerning the plaintiff, which is the person bringing suit. Publication of that defamatory statement by the defendant to a third person. And then there must be damage to the plaintiff's reputation. As I previously said, if the matter is of public concern, meaning something that the public would find value in, then 2 other elements must be proved, and that is falsity of the defamatory language and fault on the part of the defendant. So let's look at each element and break it down. When it comes to defamatory language, the meaning of defamation is anything that really harms a person's reputation. Next, we come to the of and concerning the plaintiff. The defamatory statement must relate to the plaintiff. It can't be about the plaintiff's sister, the plaintiff's brother. It has to be about the plaintiff. And there's an interesting little side twist in there when it comes to groups. So a group can bring a lawsuit for defamation if a defamatory statement refers to all members of a small group. A good number to keep in mind is about 15 people or so. If the statement is about a large group, then no member can really prove that the statement is of and concerning them. And finally, if the statement is about some members of a small group, well, then the person bringing the defamation claim may be able to show that a reasonable person could view the statement as pertaining to the plaintiff. Next, we come to publication. Publication is really a term of art. It doesn't necessarily require that the statement be posted on the internet or written or published in a book. It's really any kind of communication by any method when it's communicated to one or more people who actually understand it. So if you're at a party and everybody in that party speaks English, except you and your friend who speak Portuguese, and you scream out in Portuguese something defamatory about your friend, well, you did publicize it, you did make a publication, and it was to a third person, but it wasn't able to be understood. And publication can either be intentional or negligent. Intentional publication is where the defendant's intent was to defame this person. They intentionally spoke something or wrote something about the plaintiff. Negligent publication, for example, occurs when an individual types up a defamatory email intending just to save it on their computer, let's just say. Well, mistakenly, they press send and it goes to the whole entire company. Just an example. And then you must show damage to the plaintiff's reputation. Now this is where our slander or libel comes in. The easy way to remember the difference is I like to look at the S and take the S in slander, and that's how I keep them separate in my mind. Slander is spoken, while libel is written defamation. And whether the defamatory language is slander or libel really goes to the heart of damages and what kind of damages that the plaintiff can recover. So for libel, which is our written defamation, the plaintiff does not need to prove any kind of special damages or general damages. Now that's not the same for slander. When it comes to slander, which is our spoken defamation, the plaintiff's going to have to prove special damages. Unless that defamation, that slander, falls into one of four categories or one of four types. The first type being that the defamation reflects adversely on business or professional conduct. The second being that someone has a loathsome disease. The third, that someone is guilty of a common law crime or a crime of moral turpitude. And finally, it's defamatory to accuse a woman of being unchaste at common law. Okay, so our other two elements, the falsity and fault, come into play when there's a matter of public concern at the heart of that defamatory statement. You still must prove the four elements we just spoke about, but then you have to ask yourself, can the plaintiff prove that the defamation was false? If they can, then you have to prove fault on the part of the defendant. Here's where it gets a little hairy. If the plaintiff is a public figure or some sort of public official, then this is where the New York Times versus Sullivan comes in. You have to prove actual malice on the part of the defendant. If it's a private individual, someone unknown to anyone, well, you can either prove there was actual malice on the defendant's part or there was negligence on the defendant's part. So that's how we prove defamation. But there are some defenses the defendant can raise, and these are known as privileges. So our absolute privileges are the executive privilege, and this concerns communications by the president as well as some other members of his executive branch. Judicial privileges, and these are protections from comments by a judge or a lawyer or parties or witnesses, but the comments must be made and related to the case, the ongoing case. And then there's the legislative privilege. And this privilege applies to the legislative branch of government. For example, if the speaker's participating in a legislative proceeding. And then you have your qualified privileges. And there's 3 of the qualified privileges as well. You have a privilege to protect yourself, protect others, or protect a group or common interest. When protecting yourself, the speaker may make a statement in order to protect their own personal interests. For example, if you're walking down the street and someone picks your pocket, or you believe someone picked your pocket, and you point to someone in a crowd and say, "That man stole my wallet," well, you may be mistaken, but you had a privilege because you were protecting your personal interest. You have a privilege when you protect others, when the speaker is actually trying to protect some other person's interest. For example, a lady thinks she saw someone steal your wallet, and she says in a crowd, "Hey, that man just stole his wallet." Finally, there's a protection for the group or common interest. And this occurs when the speaker makes a statement to protect the group that he or she is a member of. And this can occur with your resumes and references. All of these qualified privileges kind of fall into that protecting interests. Finally, the qualified privileges can be lost, and they can be lost when they are abused, such as excessive publication or making a statement with malice. Then they're not going to apply anymore. Thanks for watching.
There's one other video that I wanted you guys to watch. Well, actually 2. And it is this one.
Have a seat, Mr. Walker.
So I want to sue the guy that called me a car thief. I hear that's called defamation, and I want $1 million.
Okay, before we can talk about how much to sue him for, we need to figure out if the statement was defamatory and what type of defamation it was. The kind of defamation it was can have a big impact on how much you can recover.
Okay. What do you mean by types of defamation?
There's basically 2 kinds, libel and slander.
Ah, I've heard of both of those. Did not realize they were defamation.
Yes, that's true. Libel is written defamation and slander is spoken defamation. Now, you said this guy called you a car thief. How did he make this statement?
He wrote it in the paper.
In the paper.
The local paper. $1 million, that's what I want. And an apology. I want $1 million and a great big apology.
Let me tell you a little bit about proving a defamation case so you know what you're facing.
What I'm facing? I was defamed. In fact, I think I was even libeled a little bit. You said it was in writing.
To prove a defamation case, we must prove that the defendant made a false statement that injured your reputation, that the statement wasn't privileged, and that it was communicated to someone other than you.
Yes, and we have all that. I say we sue.
First things first. You said he called you a car thief. Was this in a letter to the editor, an article, or in an editorial written by someone at the paper?
I don't see how this matters.
As I mentioned, there are some communications that are privileged. Lawmakers, for instance, and judges that sit on the bench can say things in session without being sued with things that might otherwise be defamatory in other situations. If this statement was made in the context of a news report, most reporters know to say something like, "Police report that Mr. X was arrested for car theft." You know, that kind of thing.
Oh. No, it was not written in an article. It was written in a letter to the editor by Mr. Joe Bishop. So I am going to own his house, his car, and I'm going to have him fired for what he wrote.
First things first, let's go through this point by point. What did Mr. Bishop say?
I knew you were going to ask that. And because I knew you were going to ask that, I brought a copy of the article. Give it a read.
Let me see. Well, it does mention you by name. Let's see. It also says that you are a car thief.
Ah, seen enough? You know, I'm kind of thinking at this point that $1 million might not be enough. You want to go for $2 million?
There's something else in here that bothers me.
And what's that?
It says here that you have been convicted of stealing cars. Is that true?
I did plead guilty to car theft a couple of years ago, but that was a couple of years ago. It's been a while since I've even looked at a car.
Well, you might remember what I said, that defamation is a statement about you that injured your reputation.
Yeah.
But the statement also has to be false.
What?
This statement is true, so it isn't defamation.
It's not even slander.
It's not any kind of defamation. You pled guilty to car theft, and I'm afraid that makes you a car thief.
I would watch your step, miss, because I might get you for slander. Good day.
Good day.
Interesting video. And a couple of things I wanted to highlight in that is referring to someone by name. Referring to someone by name is one thing, but when it comes to like YouTube, and that's specifically where I've seen a lot of the allegations of someone slandering them, you're slandering someone by a screen name, and that is a whole different ballgame. So you might want to be careful with that, because I don't think that's going to go anywhere, quite honestly. And I have one more video to show you. And it's pretty short and sweet.
Bye, 5 minutes. Bye.
Sorry for the ad.
Welcome to Expert Answers. Has anybody ever made derogatory comments about you to your face, on social media, Facebook, Twitter? Well, if they make the comments to your face, there's actually nothing you can do about it. However, if they make them to a third party, and they put them on social media or something like that, or in the newspaper, you can do something about it, because they've defamed you. If they say something to somebody else, that's slander. If they write something about you that's not true, of course, that's libel. And it's actionable. You can take them to court, you can get an injunction to get it to stop, you can get damages, you can get compensation, and you can get an apology from them. However, unless you're a footballer or a film star, the chances are that you haven't got the money to do that, because it's extremely expensive, it's very time consuming, and it's risky. But what you can do is you can get a solicitor to write to them, asking them to apologise and telling them to remove the comment. If you find yourself in similar circumstances and want to know whether exactly the same applies to you, why not ask us a personal question? Expert Answers. Legal advice in a click.
So that's pretty much all I have for the day, on this subject anyway. But I just wanted everyone to kind of be conscious of what you're typing and writing about people, specifically in emails or even on social media posts, because you never know how it can be taken. And I also wanted to mention, though, too, that in all my years of being in courthouses, I have yet to see a slander lawsuit alone brought. I've seen things brought up in divorce courts, but I have never seen anyone bring a slander case before a judge, just a specific slander case. So it's very rare, because attorneys have a very hard time of proving those. So just be more conscious of what you type and say, and that's pretty much all I have for the day. Hope you guys have a good day. Thank you.